Now, the next set of closing statements is going to be made by Mr. Martin Seward on behalf of the Fire Brigades Union. So, Mr. Seward, if you'd like to come up to the desk, you may begin your remarks.
Thank you, sir. Members of the panel. These oral submissions are evidence-based. The references are given in the FBU's written closing statement, or most of them anyway, for this part, and are not repeated here. Start with the true causes of the Grenfell Tower disaster. The evidence received in Module 6 shows that the fundamental underlying causes of the terrible loss of life at Grenfell Tower were political decisions made by central government from 1979 onwards in the service of a social and economic system driven by profit and greed. In particular, the disaster was a product of the neoliberal agenda over the last 40 years of deregulation, privatisation and marketisation, with the introduction of competition into the public sector in areas previously governed through direct public control. Regulation and oversight by the state of fire safety and fire and rescue services at national and local level was deregulated and replaced by looser regulation, self-regulation and guidance. The dominant mantra was that the private sector knows best, with the public sector being opened up to ever greater private provision and the public sector being increasingly run down and marginalised, especially after the regime of austerity. Corporate interests were prioritised over and above the needs and rights of citizens, particularly those living in social housing, including as to life, fire safety and equal treatment. The deregulatory agenda has been accompanied by a tolerance of cronyism and corruption and a war on health and safety regulation. We start by looking at the government which led the race to the bottom. The election in 1979 of Margaret Thatcher's government heralded a significant ideological change whereby the market and the private sector were to be set free as far as possible. In 1979, Michael Heseltine fired the starting gun for the deliberate policy of deregulation in the construction industry. He advocated the part privatisation of local authority building control and reducing the building regulations to overarching functional requirements, as set out in the consultations including the future of building control in 1981. Professor Bisbee described in his Phase 2 report how the changes first introduced by Heseltine in 1984 provided the construction industry with the flexibility it had been seeking with the creation of private building control, so that designers and contractors were no longer necessarily limited by constraints applied by a local authority building control. He said it unleashed a race to the bottom. We agree. The civil servants in DCLG agree. Mr. Bird, head of technical policy in the DCLG until 2013, told the inquiry the clear pre-1985 rules which had told builders they couldn't use a Class O panel with a polyethylene core on a high-rise were deliberately replaced by a far more innovative functional approach. Mr. Harrell, who replaced Mr. Bird, said that the Building Act 1984 was intended to deliver a system with the minimal possible government intervention to deliver compliance in the marketplace. Mr. Martin gave similar evidence, adding that market forces made building control bodies more willing to let third parties tell them something was acceptable, and that the government approach was to let the sector resolve its own problems. Mr. Bird's view that the new functional approach should have been sufficient was at best naive. The commercial marketplace is not some kind of consensus-seeking academic forum, but is driven by the commercial imperative to maximise profits, cut costs and undercut competitors. Ambiguities in the guidance for the building regulation regime caused confusion and provided a means to cut costs and corners, and for some, to bend and sometimes break the rules. What is worse is that the government was aware of all this, as is now partially admitted by JULAC at subparagraphs D and H of paragraph 6 of their closing and paragraphs 124 and 130. It knew that there were ambiguities in ADB, that the deregulated regime was failing to prevent the use of unsuitable materials on high-rise, and that markets know no morality. I'm quoting here, "It is government's responsibility to bring a balance." That's what Mr. Heseltine said at the outset. But they failed to bring that balance. The tragedy at Grenfell Tower could well have been avoided if the stricter regulatory regime of the pre-1985 building regulations had been preserved, preventing the use of combustible materials in rain screen cladding systems on existing high-rise. Introducing the functional requirement approach without adequately resourcing and supporting local authority building control was a recipe for the Grenfell Tower disaster. In view of Professor Torero's evidence, including his oral testimony on the 16th of June 2022, it's clear that the competency gap in all sectors should have been filled before deregulation. The free market, driven by the desire to maximise profit, was never going to be the correct mechanism for ensuring safety in the construction industry. As Mr. Harrell told the panel, the English marketplace failed in terms of safety. The ambiguous guidance in ADB and the failure to clarify it made compliance with and enforcement of the functional requirement much more difficult and gave the construction industry the flexibility we saw exploited in modules 1 to 3 of phase 2. The FBU asked then, why did no one on the GT refurbishment project think fire? The answer is provided in this module 6.2. The government policy of deregulation, compounded by austerity cuts, allowed fire safety to become a costly burden, which could be disregarded with impunity pending a disaster like Grenfell. We agree the written closing submissions for this part of Module 6 of the BSR Team 1 at 1.1 and 1.3, of BSR Team 2 at paragraph 3 and the paragraphs referred to earlier today by Mr. Mansfield's 81 to 85 and paragraph 159. We also agree with the Mayor's submission at paragraphs 18, 21 and 33 and note the concessions made by the current Secretary of State for DULAC in his written closing statement already cited. The government knew from 2002 specifically of the dangers posed by ACM cladding with polyethylene core. Mr. Bird admitted that by 2002, following the failed BRE test on the 18th of July 2001, he was aware A, how ACM cladding with a polyethylene core could behave in a fire and that it should not have been used over 18 metres. B, of Dr. Debbie Smith's view that Class O was at least questionable as a classification for a product to be used as or as part of an external wall over 18 metres. C, although a product such as ACM cladding could achieve a Class A reaction to fire classification, nevertheless it presented a clear external fire spread hazard. And D, that a PE cored aluminium rain screen cladding product was likely to perform dangerously with respect to external fire spread hazards. However, the government not only failed to act, but when ADB was modified again in 2006, the routes to apparent compliance were actually extended by keeping the Class O classification while introducing the option of desktop studies. These significantly weakened the already lax fire safety regime. They were brought in despite the knowledge the government possessed about the failures of ACM cladding systems in the full-scale tests of July 2001. Far from tightening up fire safety protection, the revised ADB maintained and created a regime which could be exploited by the greedy and the unprincipled. And as you're aware, even when the all-party parliamentary group on fire safety and rescue repeatedly raised concerns about ADB between 2014 and 2017, including with ministers, their concerns were given short shrift. There can be little doubt that deregulation and the failure to clarify ADB were significant factors which directly contributed to the Grenfell Tower fire. Deregulation impeded the work of civil servants in DCLG. Civil servants have consistently testified that deregulation stifled attempts within DCLG to address concerns about the ambiguities in ADB and the use of dangerous materials for cladding over 18 metres, even after the coroner's recommendations following the Lakenhall fire inquest. Mr. Bird told the panel that the deregulatory agenda of the government after 2010 had throttled the possibility of new regulation, and went on to explain the savings that had to be made before any regulatory provision could be introduced. He also said the plan to review ADB triennially was overtaken by the coalition government's policy on deregulation, that regulation was seen as a last resort, that his shrinking team spent an inordinate amount of time looking at how they could deregulate and undertaking other activities supporting deregulation at the expense of other work. Mr Leadsom told the panel that the DCLG was a deregulating department. Deregulation was an important government policy and they were addressing the spirit of what the government wanted to achieve, as well as the letter. The job of officials, he said, was to provide ministers with the widest range of deregulatory options. No new regulation could be introduced without a compensating reduction in regulation elsewhere, and there was no exemption for the building regulations. There was no process of seeking an exemption other than applying to the Secretary of State. No application for an exemption was made to the Secretary of State because they didn't think they would have got one, and it wasn't judged a fight worth having. Deregulation was the reason why the review of ADB was wrapped up into a broader review. A piecemeal review was ruled out, as it would have made it more difficult to offset any changes as required by the 1 in, 1 out, 1 in, 2 out, and 1 in, 3 out rules. This approach was agreed by the Director General. The coroner's recommendations following Lakanal did not result in ADB being exempt from the deregulatory regimes of 1 in, 1 out, etc. Mr Harrell testified that from 2015 there was a far more vigorous and aggressive approach to deregulation. He explained there was a general sense that regulation was bad, and even when there were proposals to do something that was regulatory in terms of introducing something that was attractive to ministers or something they might want to do, when they recognised it was regulation, they would pull back from that generally because that was not the way they preferred to drive change. The DCLG was frustrated by the depth and challenge of regulatory policy. Further, the policy was intended to make it difficult to introduce new regulation. Anything that involved amendment or change to an approved document triggered a regulatory impact assessment. Deregulatory policy applied to matters of life safety. This is all what Mr Harrell told us. The review of ADB had to be packaged with a wider review of the building regulations to avoid having to find the necessary savings within Part B. At the end of 2016, Mr Harrell was told by an official from the Better Regulation Unit not to consider proposing regulation because the department was struggling with its regulatory budgets. The Better Regulation agenda, he said, prevented the government acting on the improper use of materials and had an impact on people's willingness to comply with the regulations. Likewise, Ms Dawes gave evidence that the deregulatory imperative cast a shadow over teams in the department, and without rolling up the review of ADB into a wider review of the regulations which could be seen as deregulatory, it would have been difficult to progress. Between 2014 and 2017, the government adopted a far more rigorous approach to deregulation, with increased scrutiny of regulatory proposals. There needed to be very good reasons, she said, for any new regulation or the kind of regulatory oversight put in place from 2017. It would not have been very well received in 2015. Better regulation would not have happened without the Grenfell fire. She said, and she went on to explain that she found it horrific to think that it took a fire. But I honestly am not sure, she said, that it would have happened otherwise. The red tape challenge, the undervaluing of regulation, the localism agenda which removed oversight, and the demise of the Audit Commission all contributed to Brian Martin becoming what's been dubbed a single point of failure. Mr Martin told the GTI that after the 2015 general election there was an even greater ambition towards deregulation, and any document that came out from the department required political approval. Policy change and raising standards was incredibly difficult under this regime, Mr Martin told the panel. Government policy progressively hardened. The Prime Minister described people like him as an enemy of enterprise. The approach of successive governments to regulation affected resources and the mindset of the team and contributed to Mr Martin becoming a single point of failure. All this evidence fully supports our contention that its obsession with a deregulated free market was the cause of the government's failure to do anything about ambiguities in ADB and the use of dangerous materials for cladding in high-rise. Based on this, we submit the panel should find deregulation was a significant cause of the Grenfell Tower fire. Turn now, sir, to the evidence of Lord Pickles. Lord Pickles stated in his evidence that the failure to review ADB was the fault of the civil service, who misunderstood government policy, and not a consequence of the drive for deregulation by him and the rest of the government. He claimed that all fire safety regulations, including the building regulations and ADB, were exempt from the red tape challenge and deregulation. We submit the panel should prefer the evidence of the civil servants, which clearly shows the building regulations and ADB were not exempt from the red tape challenge and deregulation, and reject Lord Pickle's evidence on this matter as self-serving and untrue. Mr. Bird said that ADB and the building regulations were not exempt from deregulation policy. Mr. Leadsom said the deregulation policy applied to ADB as well as the building regs, even though it was non-mandatory guidance. Mr. Harrell said that one in and one out, etc., all applied to the building regulations and guidance. Further, the Better Regulation Framework Manual applied to both the building regulations and the guidance. Lord Pickles did partly, but not fully, exempt the Regulatory Reform Fire Safety Order from the red tape challenge and the drive for regulation. But this was not because he wished to ensure regulations relating to life, and in particular fire safety, were exempt. Instead, as he himself stated towards the start of his evidence, the Fire Safety Order was not included as it was itself a product of the deregulatory agenda. This evidence was confirmed by Mr. Leadsom, who added that a lot of the fire safety legislation was repealed when the Fire Safety Order was introduced. And from Dr. Crowder, who recalled the Fire Futures Review of December 10, which was about decentralising fire safety, government having less of a presence in fire safety, and encouraging industry to take the lead in this belief that it had, that industry would lead the way and do what it needed to do. However, the building regulations were not even partly exempted from deregulation, and there was nothing in place to ensure the life safety provisions were exempt. Lord Pickles was asked by counsel to the inquiry, were there any policies in place to ensure that departments such as yours observed their obligations to safeguard life, including under Article 2, and were properly prioritised? His answer, I can't think of anything that springs to mind, but I would hope that would be the case. Hope is not good enough for someone who is the Secretary of State, responsible for both fire safety and the policy of deregulation in his department. We submit that he knew full well that there was no such exemption, and Lord Pickles was not being honest in his evidence. Miss Dawes, the Permanent Secretary, would surely have known if there were any specific exemptions to this central government policy. However, her evidence was that she was unaware of any checks and balances to ensure the policy of deregulation didn't go too far in areas impacting life safety. Nor was she aware of any policies or guidance in place concerning the DCLG's obligations to safeguard life. There were none. Indeed, a letter from Lord Pickles dated December 2011 expressly included the building regs and ADB as part of a programme of, I quote, barrier-busting deregulation, which was expected to produce £63.6 million by regulatory cuts. Lord Pickles claimed this was a mistake due to naivety on his part, but he accepted he had authorised a deregulatory review of the building regulations, which came to be known as the Quick Wins proposal in 2010. On the second day of his evidence, when trying to show he had exempted the building regulations and ADB from the deregulatory agenda, Lord Pickles referred to several documents which he claimed supported him. They do no such thing, and the panel is asked to reject his evidence about them. Firstly, the letter exchange between Mr. Stephen Aldridge and Will Cavendish of the Cabinet Office from November 2011 wasn't even seen by Lord Pickles at the time, but in any event, it made no mention of building regulations or the ADB. His claim that it was deliberately vague is not supported by any other evidence, and the fact is that neither building regulations nor ADB were reviewed despite the recommendation of the Lackland House coroner. Secondly, a policy development document from Miss Upton in January 2012, relied on by Lord Pickles, was also not seen by him at the time. But it too made no reference to the building regulations or ADB. It was unambiguously addressing the Fire Safety Order and the King's Cross fire regulations. Lord Pickles' reference to its constructive ambiguity is self-serving and unhelpful to the inquiry. The submission containing the response to the Cabinet Office on the red tape challenge and Annex B to the submission sent to Lord Pickles' private secretary made it clear that the building regulations were not exempt. I quote, maintenance and improvement of the building regulations into the future will continue to be done in accordance with the government's approach to regulation, not least the one-in, one-out approach to regulation and the spending review commitment to reduce the burden on house builders by 2015. Lord Pickles tried to explain this by saying that there was an exemption for ADB. His assertion is both unfounded and illogical. ADB was guidance on how to comply with Part B, and therefore could not be subject to a separate standalone exemption. Other documents demonstrate beyond any reasonable doubt that the building regulations and ADB were very clearly subject to the policy of deregulation. See, e.g., the email dated the 24th of June from Jane Houghton, a government press officer, described by Lord Pickles as highly competent, which included a section cutting down red tape regulation for the construction industry. And it went on to state, building regulations have placed more burdens on industry than any other DCLG policy area. We are conducting a 2013 building regulations review to ensure they are fit for purpose and to identify opportunities to deregulate where possible. Lord Pickles unconvincingly claimed this was not policy but puff to get more coverage in the press. When pressed on this email, he became prickly, saying, "I respectfully remind you that you did promise that we would be away this morning, and I've changed my schedules to fit this in. I do have an extremely busy day meeting people, but this is more important than anything. But I would urge you to use your time wisely." The fact that deregulation was a core policy of the government from 2010 is evident from the letter from Prime Minister David Cameron in April 2011, which Mr Mansfield's already referred to. I will just cite one sentence in that letter, which he didn't cite, which was David Cameron saying, "Dear colleagues," etc., "be in no doubt all those unnecessary rules that place ridiculous burdens on our businesses and on society, they must go once and for all." Just want to emphasise the description of all those ridiculous burdens on our businesses. That's fire safety. It's ridiculous. Lord Pickles unconvincingly tried to claim the letter was not directed specifically at him, which of course is true. It was addressed to all cabinet members. He said it wasn't particularly serious as it was addressed to dear colleagues, yet it was not only copied to all ministers but also permanent secretaries who were instructed to prioritise tackling unnecessary regulation. He said it had to be seen against the background of private discussions with Mr Cameron. He seemed to be claiming that the Prime Minister had written a letter saying one thing when his intention was the opposite. The panel is asked to reject Lord Pickles' explanations concerning his letter. It clearly reflected a very important policy for the Cameron government. That deregulation was a key government policy with no exemption for life, including fire safety, was supported by evidence from some of the politicians. As follows, Lord Wharton told the GTI that he considered the work of the Building Regulations Division in the DCLG to be deregulatory. He reportedly told the APPG that there was a political policy of not increasing the burden of regulation, and the introduction of one measure would need to be offset against the removal of two others, although he couldn't actually recall having said that. He couldn't recall any specific policies to provide checks and balances to make sure that life safety issues were not compromised by the deregulatory agenda. There were none. Steve Williams agreed there was a more rigorous approach to deregulation under the coalition government. He also said Lord Pickles was sceptical about regulation and agreed there was no exemption to deregulation for health and safety. Gavin Barwell gave evidence that the Cameron government had driven hard on deregulation. The red tape challenge and the 1 in 2 out rule remained manifesto commitments in the Conservative Party manifesto, and in 2016 became the 1 in 3 out rule. However, at no stage did they take steps to allow life safety regulation by way of exemption or otherwise. David Cameron's now famous speech in January 12 showed the Conservative government gave deregulation precedence over safety when he said, "This coalition has a clear New Year's resolution to kill off the health and safety culture for good." It's simply not credible for Lord Pickles to claim that deregulation did not apply to the building regulations and ADB. Lord Pickles also claimed that no one ever discussed cladding with him in the 5 years he was Secretary of State. We asked the panel not to accept that evidence, particularly given the letter from the Lakenal House coroner. It's inconceivable that no one discussed cladding with him, or that he did not raise the issue himself, given his assurances to the coroner. Lord Pickles told the GTI, "I asked my private office and the larger conglomerate of Director Generals that I really only had 2 things I wanted from them. I always gave the same speech, which was loyalty and tell me when things are going wrong, and I promised that I wouldn't seek to blame them if things were going wrong. I would try and sort it out. And I think I can say I succeeded in doing that. I'd taken over from people who shouted at officers, who threw things about. I can safely say I never raised my voice to a single officer in the whole of those 5 years. Yet now, sir, in the face of this disaster, he is doing precisely what he said he wouldn't do. He's blaming his civil servants for something that went appallingly wrong and which was clearly his responsibility. So moving on to the fire safety order. Lord Pickles' evidence in relation to the fire safety order was simply not accurate. Although the fire safety order was not included in the red tape challenge, it was not exempt from the impact of deregulation. The deregulation policy prevented any effective review of the fire safety order, despite significant concerns over the competence of privately employed fire safety assessors and what was meant by common parts, which are both the subject of the Rule 43 letter to Lord Pickles of the Grenfell House coroner. These issues were not addressed, again, because of the policy of deregulation. When it was introduced, the fire safety order brought in a far looser self-compliance regime than the certification procedure it replaced. Louise Upton, head of DCLG Fire Safety Policy Team, agreed that the government were aware that the fire safety order would allow a mixed bag of unqualified fire risk assessors. This was a deliberate policy of government designed to spare landlords the expense of having to consult experts in fire safety. A paradigm example of the deregulatory agenda. Miss Upton testified that whilst businesses in the fire safety area wanted more regulation, we can think of the Fire Sector Federation, for example, the wider business and policy environment was for less regulation. They were in a very deregulatory environment. The government did not support the sector's efforts over the fire risk assessor competency because the policy was hands-off. Ministers didn't want to review the fire safety order because of the deregulatory agenda. That's what she said. The general thrust of deregulatory policy, she further said, led to 43 fire and rescue authorities all enforcing the fire safety order in different ways. It wasn't just civil servants who took this view. Dennis Davis of the Fire Sector Federation said that mandatory competence requirements for fire risk assessors was opposed by a deregulating government. Brandon Lewis effectively accepted that despite evidence that the sector was failing, the government failed to address the issue of the fire risk assessor competence, both because of the ideological presumption against regulation and because government did not consider the cumulative evidence. He expressly recognised a political predisposition against further regulation in the field of fire safety. There's a direct causal link to the Grenfell Tower disaster here. Deregulatory policy resulted in the appointment of Mr. Carl Stokes, who was insufficiently qualified and not competent to risk assess the fire safety of such a complex building. Mr. Stokes is by no means unique, as was reported by Her Honour Judge Francis Kirkham after the Glasson House inquest and by Senior Coroner Nigel Meadows after the inquest into the death of firefighter Stephen Hunt in Paul's Hair World in Oldham Street, Manchester. The civil servants were clear that commercial interests took precedence over life safety. Selecting just a small sample of the evidence, Ms Upton said that the government were more interested in the wheels of the fire safety order running smoothly for business than in legislating for competent accredited fire risk assessors, and that the government had a business-led agenda that lost proportion on cutting regulation and lost sight of important matters. Mr Leadsom said that any change, even to the guidance, was seen as disruptive and costly to the construction industry. He explained the wrapping up of the review of ADB into a broader review was due to the cost-benefit to business criteria, and said there was no principle that balanced life safety against cost. Mr Harrell explained that even just looking at a document was seen as creating a cost for industry. He agreed that there was a clear level of commitment in government to deregulation, irrespective of life safety. And Mr Martin said lower standards of fire safety were accepted by the government for economic reasons. The government didn't want to impose the cost of large-scale fire testing on business. The retention of Class O was for market distortion, not fire safety reasons, and was politically motivated. He said a review of ADB would have had a disruptive effect on the construction industry at a time that the government was very focused on avoiding anything that might impact the economy in a negative way. He said that every review had to consider transitional costs, and the Regulatory Policy Committee would have rejected anything that did not recognise that people would have to familiarise themselves with the new guidance document. There was a competition between government departments as to which could save industry the most money through deregulation. This was dismissed as sibling rivalry by Lord Pickles, but it can be seen clearly in a document published by the Department for Business Innovation and Skills in December 2014. A table headed Table 2, Departmental Regulation, and regulation from 2011 to July 2015 showed the DCLG made a net saving to business over the Parliament of £201 million. Please screen page 2 of Professor Bisbee's report. It's the first document on the list. Thank you. And if you you could see his paragraph. Where are we? Well, I can read it from here. Hopefully you can find it there. By the time, it's paragraph 6. There we are. By the time of the Grenfell Tower fire, there'd been numerous opportunities where the statutory guidance and regulatory compliance testing regime could have been made simpler or less permissive. However, in each case, there appears to have been powerful commercial and ideological incentives to increase complexity while also increasing flexibility for industry. In our opening for Module 6, we submitted that the drive for deregulation and the war on health and safety created a culture of complacency with an increasingly prevailing attitude that safety did not matter. Following the oral evidence in Module 6, we would now go further and say that the government showed a callous disregard for health and safety. It was simply not an issue for them. All that mattered were commercial interests. It can come as no surprise that given this culture, private sector companies involved in the refurbishment of Grenfell Tower behaved as they did. Safety considerations were not an issue for the government, so why should they be for anyone else? Government ministers and officials ignored and suppressed inconvenient reports and evidence that might have prompted measures that could have prevented the fire at Grenfell Tower. An example is the government's failure to publish the report of the failed BRE tests on the 18th of July 2001 on ACM cladding with a polyethylene core. Mr. Bird accepted that even though the government were around that very time consulting on revisions to ADB, these reports and data had not been put into the public domain, that they should have been published, and that the BRE would not normally publish reports of this sort by themselves without the consent of government. That's Mr. Bird acknowledging that they should have been and were not published. Mr. Bird denied there was a cover-up, but he had no explanation for the failure to publish this crucial evidence, and we submit it was not simply an oversight. The government chose to put profit ahead of fire safety. As reported by Professor Bisbee, rather than eliminating the use of Class 0 for external cladding products, or alternatively more tightly restricting its application to products where the testing methods underpinning a Class 0 classification were more technically credible, the government chose to simply add a new and potentially lucrative to the recently privatised BRE alternative route to demonstrating compliance with the recommendations of Approved Document B, i.e. large-scale fire testing to BS 8414. The DCLG did not want to know about fire safety problems and deliberately buried its departmental head in the sand. The instruction to play down the issue of the fire in the aftermath of the Knowsley Heights fire and recorded in a handwritten note in file AT66/389 uncovered by Professor Bisbee indicates government thinking at the time. Don't tell me, I don't want to know. From October 2012, ministers required the BRE not to make any policy recommendations or propose revisions of ADB as part of deregulation. That's requiring the BRE not to make any policy recommendations or propose any revisions of ADB. No clearer example of burying head in sand. This was reinforced by an instruction from Debbie Smith at the BRE to fire safety staff not to raise issues directly with the DCLG. Likewise, the BRE's government contract to investigate and report on real fires was changed to prohibit on-site investigations, save with the specific agreement of the department. Ministers woefully failed to interrogate such reports as they did receive. What are they getting paid for? In his comprehensive Phase 2 report, Professor Bisbee set out a detailed analysis of the investigations following various major fires since 1991. He notes in each instance the flaws in the investigations and the failure of government to learn any lessons from them. The following should all have been interrogated, by which I mean read intelligently, understood, and questions asked. They were not, and the only credible explanation is that the government didn't care. So after the investigation into Knowsley Heights in April 1991, which found that the cladding complied with Class 0, no concerns were raised as to whether this provision was adequate, nor to what extent the GRP rain screen product may have contributed to the fire. After Garnet Court in 1999, where the fire rapidly spread via the external cladding, there was little or no investigation of the contribution of the cladding to the fire. The cladding did not satisfy Class 0, which should have raised concerns about non-compliance and enforcement. None were raised. No questions were asked. After the Edge fire in Salford in 2005, another rapidly spreading cladding fire, Professor Bisbee says the BRE investigation failed to achieve any of its objectives, but no questions were asked. After Lecknell House in 2009, no questions were asked nor any action taken, despite the Coroner's Rule 43 letter. Professor Bisbee concludes that following Lecknell House fire, at the latest, Class 0 should have been withdrawn. Had this step been taken, the disaster might never have happened. Again, to cite Professor Bisbee, the consequence of the choice to retain Class 0 in 2002 would manifest in many subsequent fires over the following 15 years. However, none of these events were apparently sufficient to motivate the government to withdraw Class 0. It would take the deaths of 72 people at Grenfell Tower to motivate government into withdrawing Class 0 and into disrupting industry status quo. Only then did government see fit to act on Class 0 and to discontinue its use. There was a readily available alternative to the testing regime in the European Union, which the UK was still part of at that time. The harmonisation of methods of fire testing and reaction to fire and fire resistance, based on EU standards, could have had a huge impact on safety. However, it would also affect the profits of manufacturers and their ability to sell their current products on the UK market. The government was aware of this and exploited their ability to delay the transition period and to determine the equivalence between the testing regimes to the full. Consequently, even though they were aware of the inadequacies of Class 0 compared to the EU standards, and that by maintaining Class 0 the UK market would be open to cladding products of inferior reaction to fire performance, I'm citing from Mr. Bird, they continue to allow it to be used purely for commercial reasons. That's what Dr. Crowder said, with devastating consequences at Grenfell Tower. As identified by those representing the BSRs, the consistent pattern of inadequate investigation and suppression of reports from Knowsley to Garnock through to Edge and Lacknell goes beyond mere accident. It involves government collusion and reflects a corrupt culture. The government regarded fires as something to be covered up or trivialised, such that the public might be reassured and avoid criticism of underlying regulations, thereby continuing to allow industry the latitude it wanted. We pointed out in our opening to Module 6 that as well as a lack of competence, the involvement of the private sector brought with it a culture of deceit, cronyism and corruption. We illustrated this with a number of evidential examples. Kingspan were clearly pleased with government policy, including the delay of introducing EU testing standards. Its technical bulletin in May 2003 stated of the new European fire classification system, existing national fire standards are set to be withdrawn for 5 to 10 years. HM government has stated it will not implement the new Euroclass system until the industry is ready to adopt it. In fact, the delay went well beyond 5 to 10 years, and by 2017, Class 0 was still in use and EU standards were not in place. The Grenfell Tower inquiry has not investigated in any depth the extent of collusion, including lobbying of ministers and other politicians or officials behind the scenes by companies such as Kingspan. Whether or not there was more active collusion or corruption, we submit that government policy was driven by commercial considerations to the detriment of fire safety, and this ultimately led to the disaster at Grenfell Tower. So I'm about halfway through. How are we doing? Still on time?
Yes, you're doing reasonably well.
Reasonably well. I'll certainly live with that. So moving on to the next big topic, which is the building research establishment. The BRE was first threatened with privatisation in 1981. It was turned into a more commercial organisation during the 1980s and became an executive agency in 1990. By that time, it had lost half its staff and was operating under market imperatives. BRE's privatisation in 1997 brought commercial pressures and conflicts of interest into the heart of the fire safety regime and limited the work the BRE could do in the public interest. Professor Bisbee cites the following passage from the BRE's Deputy Director then, Peter Field, and his evidence to the Parliamentary Inquiry in 1999. "We are a private sector organisation," he told the Select Committee. "We are not part of government. Clearly, in days gone by, when we were part of government, then this work would have been done in the public interest without the need for formal contract. One regrets there are now commercial pressures that require clients to place formal contracts with us before we can undertake work." Since its privatisation in 1997, the BRE has failed the wider public interest and been too ready to accept the restrictions imposed upon it by central government and too willing to collaborate with manufacturers. A correction is needed to our written closing statement, FBU 60191, at page 32, paragraph 86. I accept Sam Leake QC's submission at paragraph 4 of her closing statement that the BRE was not a regulator. So where I wrote that the BRE was more collaborator than regulator, I correct that to more collaborator than independent contractor. However, we consider that the parameters of BRE's work and obligations went further than was permitted or required under its individual contracts and the regulatory requirements affecting such work as she submits. Please screen page 4 of the BRE's written closing statement. It's page 4, it's paragraph 13, if you could enlarge paragraph 13 so it's legible. Thank you very much. Miss Leake submits there that the BRE was a charity with a mission to support research into the built environment for the public benefit. Those are the important words I want to draw to the panel's attention. With a charity with a mission to support research into the built environment for the public benefit. If you you could probably go to paragraph 15. It's on the same page, actually. If you just go down to paragraph 15. Thank you. And she submits the trust and charity structures were deliberately put in place to retain the authority and independence that BRE had developed while publicly funded and to avoid the BRE being driven in any one direction by commercial pressures. We submit this charitable mission should have permeated everything the BRE did, including negotiating its contracts and discharging its contractual duties. The BRE should, we say, have remained in the public sector, and it should now be taken back into the public sector. But as things were as a charity, at the least it should have carried out its charitable mission. Please now screen page 3 of the BRE's Code of Conduct and Ethics Policy. So that's page 3 of BRE. Thank you very much. And so under the higher heading, Respect for Life, Law and the Public Good, this says, we give due weight to the wider public interest. And it goes on, will minimise and justify any adverse effect on society and hold paramount the health and safety of others. And then under the next heading, Expertise, Science and Research, it says, we hold a privileged and trusted position in society and thus expect to demonstrate we are seeking to serve wider society and to be sensitive to public concerns and to demonstrate that we are aware of the issues that science and technology raise for society. Those are fine words, but the evidence from Module 6.2 shows that post-privatisation, the BRE took the benefit of being seen to be authoritative, independent and serving the public interest, without bearing the burden of carrying out its contractual work in manner consistent with its charitable objectives and its code of conduct. This it failed to do. So when investigating files for the government or for other customers, it did not conduct research into the built environment for the public benefit, but for the benefit of its customer, the government. And when discharging contractual duties for commercial clients, it readily agreed to keep fire data confidential to its customer without any exception in the public interest. Accordingly, it did not hold paramount the health and safety of others or give due weight to the wider public interest, or minimise and justify any adverse effect on society, nor did it seek to serve wider society and to be sensitive to public concerns, or to demonstrate that it was aware of the issues that fire science and technology raise for society. From being a publicly funded safety body, the BRE became a tool for use by government to limit its research and suppress fire data, and for use by manufacturers to market their products, whether they were safe or not. Sadly, the BRE has now lost the authority and independence that it had developed while it was publicly funded. How did this happen? It happened because the BRE could not overcome the challenges to its independence introduced by privatisation in the toxic culture created by the government's war on health and safety. Instead, financial dependency on manufacturers and on a government increasingly disinterested in fire safety led to unresolved conflicts of interest, the loss of independence, and reduced health and safety research. Dealing with conflicts of interest first, the BRE largely depended on contracts with government, but also looked to industry for sponsorship and sold fire tests to commercial clients for revenue. All of these activities were obviously loaded with potential conflicts of interest post-privatisation, particularly with a government disinterested in fire safety. For example, Dr. Crowder gave evidence, albeit hearsay, of the lobbying pressure from industry on government to preserve reliance on Class O and Class 0, despite him wanting to dispense with it, and Brian Martin asserting a desire to discontinue it at some point. Dr. Smith, the Senior Director of BRE, was unaware of any discussions within the BRE or with government about whether it was in the public interest that private businesses should sell fire safety tests for revenue, and made no effort to find out or consider possible safeguards of the public interest. She agreed with counsel to the inquiry that her emails about the CWCT guidance on ACM cladding might be read as indicating that her sole concern was to protect the BRE's revenue streams and that she was not interested in matters of public fire safety. Pardon me. She said commercial bodies were never willing to fund fundamental research or experiments for the benefit of a better understanding of fire safety in the public interest. Dr. Colwell also told the panel the potential conflict of interest between life safety and commercial gain was never discussed, and so it seems, members of the panel, that the BRE seems never to have challenged their clients' demand for confidentiality, not negotiating a public interest exception to the confidentiality clauses in its contracts. There is no evidence that Dr. Smith or Colwell or anyone else at the BRE attempted to negotiate a variation of the contractual obligation where it conflicted with the wider public interest, or otherwise put the case for publication to alert other interested parties of fire safety risks. The BRE cites a British standard in their closing statement as requiring it to preserve clients' confidentiality. But paragraph 4.2.1 of that British standard provided, and I quote, "The laboratory shall inform the customer in advance of the information it intends to place in the public domain." So why didn't the BRE do this? We invite the panel to conclude that commercial and government interests prevented the BRE from notifying its clients that it would put information into the public domain, or at least share with other testing houses and regulatory bodies information about failed tests or policy recommendations that arose from its work. The BRE could and should have insisted upon incorporating a public interest exception to the confidentiality clause in its contracts, both with commercial clients and the government. The BRE could then have published failed test results and made public its concerns about fire safety, but it didn't. Moving on to policy implication reports, even without a public interest exemption, it could have issued a policy implications report to the government when appropriate, but it didn't. Our search of relativity found no policy implications reports for DCLG or on amending the guidance in ADB or otherwise on the risks associated with the use of ACM panels on high-rise buildings before the Grenfell Tower fire. Not publishing failed test results. Dr. Smith agreed, when asked by counsel to the inquiries, it would have been beneficial for public safety in relation to the BRE's work in the service of wider society, quoting from the Code of Conduct, to insist that failed tests be put into the public domain. But it didn't. Instead, the commercial imperative after privatisation disposed the BRE to favour the commercial interest of its clients over the wider public interest, not pursuing concerns about fire safety. Mr. Baker of the BRE agreed that Kingspan's product literature of 2013 was misleading. That was on day 100, it wasn't in this last module. But he could not recall the BRE taking any action to address these concerns. He said the BRE was not a regulatory body and didn't have the power to do anything. But the BRE could and should have insisted upon incorporating a public interest exception to the confidentiality clause in its contracts. BRE could then have published failed test results and made public its concerns, but it didn't. Not advising government properly of the risks. BRE's review of what is better known as Contract CC 1924, I'm sure that's how you'll remember it, back in 2000 to 2001, produced very clear evidence that the aluminium rain screen product used in the rain screen System 5 test, that's one of the tests conducted, was obviously unsuitable for external cladding applications and ought to have raised an alarm. It seems likely that this was an ACM PE rain screen cladding product of the same type as that which was later used for the rain screen cladding at Grenfell Tower. Dr. Smith testified that she was not in any doubt after the rain screen System 5 test that ACM panels with a polyethylene core should never ever be used above 18 metres. But she did not include clear advice to this effect in the report to government. She said the BRE's role was to present the technical evidence and data and signal what they think needs to be considered. Then it's for government to consider and decide what to do. It appears, however, that she didn't even signal to government this critical public safety issue needed to be considered. No policy implications report or other similar document was given to government. Also not advising other interested parties or the public. Dr. Smith said she couldn't advise other parties of the dangers of ACM panels with the polyethylene core because of the contractual obligation to keep reports confidential since privatisation. She said it was a matter for the department, not for the BRE. We disagree for the reasons I've already outlined. Not sharing fire data with others in the fire safety regime. Of the BRE's refusal to respond to CWCT's concerns about cladding, Dr. Smith told the panel, tellingly, CWCT are a competitor. I mean, how much time, she said, how much time do you devote in terms of our effort and resources in producing documents for others? Where, we ask, was the wider public interest? The wider public interest was subverted to the commercial imperative of suppressing a competitor in the marketplace. Not guarding against cheating, Dr. Smith realised it was always possible that manufacturers might attempt to game any aspect of the testing system, including by willfully cheating. Yet neither she nor anyone else in BRE took adequate steps to minimise the risk of it happening. She appears not to have considered steps that could have been taken, such as taking a full suite of photographs of the test rig or insisting that BRE employees set up the test rig according to the customer's design specification. Sometimes even actively assisting manufacturers to game the tests. It's obviously a matter for the panel to determine on the evidence, but Mr. Room of Silatex and Mr. Meredith of Kingspan both testified that Stephen Howard and, they said, either Dr. Sarah Colwell or Phil Clark of the BRE helped them devise tests that stood a better chance of passing and to better market their products. Insufficient funds for health and safety research. Apart from modest funding available for research from the BRE Trust, for which staff could bid every now and again, the BRE had to fund itself completely after 2002. There was a sort of a subsidy until then, and generate an income for each work stream carried out. So post-privatisation, the BRE did not have the resources to support all the health and safety work that it needed to do, like attending standards committees, to do the testing it wanted to do. So, for example, in contract CC 1924, testing of the external wall build-up with and without fire barriers was not undertaken. Doctors Colwell, Crowder and Smith all confirmed that less work in support of fire safety research was carried out across the board post-privatisation, and the BRE investigated fewer fires as a result. Dr. Smith also said less work in support of ADB was carried out post-privatisation. She told the panel, so you have to sit down and take decisions about which activities you can afford to support, and that's really the environment which we've had to exist since privatisation. There's nobody there that's funding those tendencies. Dr. Crowder said his information about the Sudbury House and Taplow House fires, 2 separate fires, was gleaned from press reports, not from a BRE investigation. He said the resources were not available to capture data and identify trends. Research had to stop at the limits imposed by clients and their budgets, meaning fundamentals were not understood. There was a reduced independence from government control of fire safety research after privatisation. The BRE could only do the research that the government procured. If the intended research wasn't aligned with particular government policy objectives, then it probably wouldn't get funded. After privatisation, the BRE lacked sufficient independence to carry out the necessary research in face of a government increasingly disinterested in fire safety. And on to the inadequate and misleading investigations. After, and we say largely due to privatisation, the BRE carried out a series of inadequate and dangerously misleading fire investigations and research projects, and I've already mentioned Knowsley Heights through to Lakenhall House and right up to Grenfell Fire. The common thread in these investigations is that they failed to report, let alone to highlight, the contribution to any of these fires made by or the combustibility of Class 0 rain screen products used. This is set out in Professor Bisbee's report, which raises many questions, particularly about the conduct of the BRE. We've highlighted several of these failed investigations in our closing statement and do not repeat them here. On each occasion, the privatised BRE was prevented from performing its proper function due, we submit, to deregulation and the commercial considerations which were given precedence over public safety. So to summarise, after privatisation, the BRE's financial dependence on a government increasingly disinterested in fire safety and on commercial clients with their own agenda led the BRE to fail the fire safety regime by not negotiating a public interest exception to the confidentiality clause, not issuing policy implication reports, not publishing failed test results, not pursuing concerns about fire safety, not advising government properly, not investigating fires properly, not advising other interested parties or the public, not publishing fire safety research findings, not sharing fire data with others in the fire safety regime, not guarding against the known risk of cheating the fire tests, sometimes even possibly actively assisting manufacturers to gain the tests. So that concludes our submissions on the BRE. We've already referred at length in our submissions to the BBA and the NHBC and UCAS, and don't repeat those here. But if time permits, a few words on the LABC. The local authority building control is a clear example of regulatory capture. Privatisation and the introduction of competition had a disastrous effect on building control. Shockingly, it ultimately led to the LABC falsely certifying products as being of limited combustibility because of commercial interests. Before I go on any further, sir, I don't want to fall into the same trap. How much time have I got left?
Well, how much time do you need?
Well, I think I probably need about 5 minutes, maybe 10.
Oh, you're well in. You're fine at that.
I'm fine at that. Okay.
Yes.
Okay. Thank you. That's fine.
Good. Thank you very much.
That was very well negotiated. So you didn't actually give me a time.
Well, I didn't wish either to cramp your style or to
No.
extend it too far. But
No,
you're doing all right. I'll indicate if I think you're running out of time.
Yep. Okay. Thank you very much. So Barry Turner was a senior technical advisor at London Local Authority Building Control, LABC. And that was an influential membership organisation which advised, supported and promoted local authority building control bodies who had difficulty competing for business with private building controllers. He said, enforcement is difficult to sell, developers don't want you looking over their shoulder. LABC was not publicly funded, and like the local authority building control bodies that it supported, it needed to generate income in a competitive market. This provided ample scope for regulatory capture and the LABC was well and truly captured by Kingspan. For a price, it issued type approval certificates, and after 2010, registered details for building products which Mr Turner understood would be relied upon to fast-track building control approval on developments specifying those products. For example, LABC issued a type approval certificate for Kingspan's K15 insulation product in May 2009, which falsely stated it could be considered a material of limited combustibility. Mr Turner now accepts that this was inaccurate and misleading, but he could not explain how it came to be issued, despite concerns raised by members of the technical working group, which concerns were overlooked. LABC also collaborated with Kingspan on a number of projects and accepted sponsorship by Kingspan. Mr Turner accepted that this relationship probably affected the way LABC responded to concerns raised about Kingspan's fire performance statements. For example, from September 2009, Mr Cody of Rockwell complained to Mr Turner about Kingspan's claims that K15 was of limited combustibility. Mr Turner could not explain why he neither invoked LABC's complaints procedure nor replied substantively to Mr Cody, nor why he did not consult the BRE until June 2015. Incredibly, he turned instead to Kingspan's head of marketing before responding, at which stage, again incredibly, he defended the certificate. He neither reviewed nor withdrew the certificate. He said he would have dealt with it differently if he had appreciated the risk to public safety. He was a chartered building control surveyor and member of the Royal Institute of Chartered Surveyors with over 53 years' experience. We submit Mr Turner must have realised the risk to public safety of wrongly certifying a K15 product of limited combustibility. His false assertion that it was of limited combustibility revealed the truth, that the LABC was serving the manufacturers, not the public's interest. Once again, commercial interests took precedence over public safety. David Ewing also now accepts it was a pretty major error to certify that K15 could be considered a material of limited combustibility, there being absolutely no test evidence in support. Likewise, he now acknowledges the claim made in the LABC Registered Details Certificate of August 2013 that K15 was suitable for use above 18 metres, but not substantiated by the technical data provided by Kingspan. David Ewing was LABC's Technical Sales Director, in charge of the Registered Details Scheme. In July 2014, he was made aware of Brian Martin's concerns about the use of combustible insulation above 18 metres in his email exchange with Steve Evans of the NHBC, but he did not act in the public interest by, for example, alerting LABC's members to the issue or checking all certificates issued for K15. The only credible explanation is LABC's financial dependency on Kingspan. Mr Lewis says that issuing K15 Registered Details Certificate in August 14, based on the 2008 BBA certificate, and despite Brian Martin's concerns, was an oversight. He denied feeling any pressure, e.g. from Phil Hammond, the LABC Managing Director, to increase the number of registered details registrations, or of knowing this contributed to Martin Taylor's decision to leave LABC. He further says he trusted Kingspan that they would not be providing inaccurate information. But any such trust could not have survived the warning from Steve Evans in August 2014 that Kingspan were not going to be able to prove that K15 was acceptable above 18 metres. His oral evidence on these points is, we submit, unbelievable. He did not act in the public interest and check Kingspan's assertion because it was not in LABC's commercial interest to do so. Mr Ewing and the LABC were likewise played by Celotex in August 14 when they failed to obtain any classification report before issuing a registered details certificate to Celotex in respect of its FR 5000 product, stating falsely it was suitable for use above 18 metres. The part privatisation of building control, coupled with the absence of public funds or any proper governmental oversight, led to LABC's predictable yet shameful dependency on its fees earned from manufacturers. The LABC certificates facilitated the successful marketing of combustible insulation for use above 18 metres over an extended period from August 2009 up and down the country, including at Grenfell Tower. The LABC's failures were themselves the consequence of a failed regulatory system that was not fit for purpose. Moving on to the response to the coroner's letter following Lacknell House inquest, just briefly a few points. As the GTI is aware, Lord Pickles, the Rule 43 letter to Lord Pickles included a number of recommendations that he review the content of the building regulations, and in particular ADB, to provide clearer and simpler guidance in relation to matters such as the spread of fire over the exterior of a building. By the time of the Grenfell Tower fire, some 4 years later, no such review had been undertaken. In fact, Lord Pickles failed to take any effective steps to respond to the Coroner's Rule 43 letter. Following the oral evidence in Module 6, we submit that the simple explanation for the failure of the DCLG in relation to the Coroner's letter is that it did not fit in with the drive to deregulate and to prioritise commercial interests. Consequently, it was ignored. We submit there's an urgent need for a national oversight body to consider Rule 43 letters and other recommendations from inquiries to ensure they are properly reviewed and implemented. Failings in government. The evidence in Module 6 has shown that there were significant failings in the DCLG, including by Brian Martin, who has been called the single point of failure. However, we submit it would be wholly wrong to try and lay the blame for the Grenfell disaster on a middle-ranking civil servant. To the extent that senior government ministers have sought to do this, we submit that represents a shameful abdication of their responsibility. Mr. Martin has admitted his failings and expressed remorse at their consequences. This is in stark contrast to the evidence of the politicians who either couldn't remember or, as in the case of Lord Pickles, sought to blame others, including Mr. Martin. We also note that he wasn't separately represented. It's wrong and reprehensible that senior politicians who were responsible for the DCLG should seek to blame Mr. Martin. We do not accept that any single point of failure by a civil servant caused the Grenfell Tower disaster. The fire at Grenfell Tower was the consequence of decades of policies promoting commercial interests at the expense of everything else, including fire safety. It happened due to the war on regulation as an albatross around the neck of business. Mr. Martin was a product of this environment, not its cause. In our opening in Module 6, we contended that side by side with ever more zealous promotion by central government of deregulation in the commercial interests of the private sector was the degrading and undermining of the public sector. Further, over recent years, that process has accelerated as a consequence of austerity and cuts in public expenditure. We submit that the oral evidence in Module 6 has further supported those contentions. There were cuts in civil service staff. The reduction in staff in the civil service, including in the DCLG, was clearly an issue, and the falling headcount reduced its effectiveness. Mr. Bird told the panel that the headcount in his section of the DCLG had gone down by 40% in the time he was there. And this, we have to remember, is at a time when Professor Torero has explained the building environment was become ever more increasingly complex. He said declining resources, both in terms of research monies and in terms of headcount, coupled with the undertaking of and being cognizant of the various deregulatory measures, meant they had less and less time to focus on the building regulations. Mr. Harrell also referred to the reduction in resources, including headcount. In 2006, he said there were 14 construction professionals in a division with a much smaller scope of work. There were 3 grade 6s supporting the deputy director. By 2015, this had reduced to 5 technical specialists with 1 grade 6, Mr. Martin. And he went on to describe those resource pressures as tectonic. Ms. Dawes also gave similar evidence about the lack of resources, and I won't take up time with those. But we submit that the performance of civil servants in the DCLG has to be evaluated against this background of significant cuts in staff. These policies are not just about numbers, they have real life consequences beyond people losing their jobs. Miss Dawes was asked to comment on an email sent to her on the 20th of June, asking how the DCLG might have incentivised RBK's choice of the contractor Ryden, who made the lowest bid. She answered, she's talking about the cuts to local council funding. The budgets for housing were very tight indeed. Grenfell Tower, along with much of social housing, has suffered decades of neglect and lack of investment. This too is a consequence of central government policy. RBKC's housing stock was no different from that in the rest of the country. Although RBKC is a well-off local authority, the council were unable to invest any of their general funds in social housing because central government policy had restricted the available monies to those which were generated by rents in the housing revenue account. Miss Dawes went on to explain how matters deteriorated in 2015. But we were also very concerned just about general funding for any form of social housing investment, which had been stopped in the first year of the government following 2015, although it was reinstated later when Gavin Barwell and Sajid Javid did their housing work. But we were worried about that as well, because that was just simply to keep house building going in the social sector. This evidence shows how central government policies forced poor choices on local housing authorities, including the use of inexperienced and inadequate contractors using poor and dangerous materials. Shoddy workmanship was common, as we highlighted in our opening submissions, and this issue too was addressed in Ms Dawes' evidence. Were you aware of this open secret being the inconsistent standards and tolerance of shoddy work? Were you aware of that? Asked counsel. And she said, yes, I think I was. Were you aware of inconsistent standards and tolerance of shoddy work by building control authorities before the Grenfell Tower fire? Well, I can't remember. The impact of austerity and cuts as a contributing cause to the Grenfell Tower fire cannot be overlooked. And of course, there's the ongoing impact of austerity. Louise Upton, during her evidence, said there was little value in PEEPs without someone being there to implement them, and that to recommend that those who manage high-rise maintain information on vulnerable or disabled occupants would place a significant burden on them. Now, you can take it from me, she said, that this response she was asked the question, and the questioner, counsel, put to her, now you can take it from me, that this response didn't tell Elspeth Grant that the underlying rationale for the LGA's guide position on PEEPs was an anxiety to avoid imposing disproportionate burdens on landlords. Do you know why that rationale was not explained to Elspeth Grant? No. Would you accept that it should have been in a spirit of candour? Yes. The advice of a disability expert wasn't sought by the Home Office or anyone else. Miss Upton had no knowledge of disability law. It's clear that commercial interests of landlords are still the priority, even today, over lives of disabled people. Finally, the lack of caretakers or concierge is itself the direct result of cuts in resources for social housing stretching back decades. Austerity and commercial interests continue to prevent issues in high-rise being effectively addressed today. And we've just seen the latest recommendation on the government website not to implement your recommendation regarding PEEPs, as Mr Mansfield explained earlier. As to the Fire and Rescue Service, the Home Office portrays the White Paper as progressive and positive. The proposals set out in the White Paper, it says, seek to strengthen fire as a profession, enabling fire and rescue professionals to improve their skills and fully serve the community, as well as unlocking and nurturing talent. The proposals seek to support a positive culture and to improve diversity and inclusion. In addition to this, the government intends to commission an independent review into the current pay negotiation process and consider whether it's fit for a modern emergency service. The FBU knows from bitter experience that this heralds an attack on collective bargaining, which has nothing to do with the Grenfell Tower disaster, or the steps which the government should be taking to prevent a recurrence. Conclusion, the central state has a fundamental responsibility for the safety of its citizens in a modern society. We submit that central government has failed woefully in this task. They failed to regulate high-rise, in particular by avoiding the foreseeable hazards of insulating them against the cold and rain through installing safe rain screen cladding systems. They've cut back regulations and allowed businesses to ignore safety rules as part of a war on health and safety culture and to prioritise profit over safety. They've abdicated the duty to research emerging fire risks and develop protection measures. Whereas for half a century, central government had an authoritative statutory fire and rescue advisory body that strategically assessed the risks and provided ministers with reliable expertise, that body was abolished as part of deregulation at a time when the built environment was increasing in complexity. The philosophy of deregulation has blighted efforts to improve and has actually worsened the living conditions of millions of people. Grenfell Tower was the culmination of more than 4 decades worth of these policies. Those who lost their lives were also the victims of big business and an economic and social system that values the generation of wealth over the protection of those without the wealth to protect themselves. In the scramble for profits, those people were collateral damage. Central government and the economic system which they nurture bear ultimate responsibility for the Grenfell Tower fire. Thank you for your patience.
Thank you very much, Mr Seward. Well, it's a little earlier than usual for a break, but we did start earlier after lunch, so I think probably this is a good time to take the afternoon break. We'll stop there and we'll resume, please, at 3:15 when we'll hear a closing statement on behalf of the London Fire Commissioner. Thank you very much. 3:15, please. The next statement is going to be made by Mr. Stephen Walsh on behalf of the London Fire Commissioner. So, yes, Mr. Walsh, when you're ready.
Good afternoon, Sir, Ms. Estefan, Mr. Atbor. So in this month of June, 5 years on from the tragedy in 2017, may I begin these relatively brief observations on the issues which arose in Module 6B, as I will call it, by again assuring you that the constant and ongoing work which the Brigade is engaged in to meet your recommendations in the Phase 1 report remains a priority for the London Fire Commissioner. As you know, there is much to do across a range of the Brigade's operations. And while a great deal has already been achieved, some of the improvements and the changes are complex and will take time to progress. But nevertheless, 26 of the 29 recommendations which related to the LFB have been completed, and a further 2 are to be completed by the end of the year. It just seemed an appropriate time in June to update you all.
Thank you, yes.
And those who are listening. So I know that the panel will have read our closing statement for Module 6B, and it's publicly available. So as usual, I have no intention of repeating it all here, although I may well, probably will, repeat 1 or 2 of the points which have been made by others during the course of the day. Forgive me for that, but those are points which actually do bear repetition. I do, though, want to say something about the importance of context. The phrase context is everything might be, probably is, overused, and sometimes it's misunderstood, but it is a particularly felicitous phrase when applied to the Grenfell Tower tragedy, at least insofar as the operational response of the fire service is concerned. Whether it is the sheer scale and rapidity of the fire and the impact on operational resources that had and in the control room, or the chain of events which led to the building being shrouded in highly flammable materials, or the impact which the political atmosphere of deregulation had upon the efficacy of the building regulations, just to give 3 examples of so many other matters of context, a full understanding of the wider context is essential to a proper and fair assessment of the emergency response of the fire service on the night of the 14th of June 2017. But more importantly, it's also essential for the purposes of learning from the events of the past so that really effective and meaningful changes can be made. Now, the reason why that's relevant to the submissions that I make today is that module by module in Phase 2, the evidence has provided a very substantial body of essential context from multiple witnesses on a wide range of issues, which were explored, as you know, with the LFB almost solely in Phase 1. The evidence in Module 6B has been of vital importance to a proper understanding of the extent to which aluminium composite material panels with a polyethylene core, ACMPE, were generally known to be in use on residential high-rise buildings, and the effectiveness of the building regulations in preventing such use. And when I refer to the building regulations, I include approved document B, although of course I recognise that one provides the functional requirements and one provides the route, the suggested route to compliance. We highlight ACMPE here rather than dealing with modern materials generally and what was known about them, because obviously the evidence is very clear that it was that product and the system within which it was designed and installed which was the principal cause of the manner in which the Grenfell Tower fire behaved and the devastating speed of its extensive spread. As Professor Bisbee reminded us only last week, it was the polyethylene core which was responsible not only for the velocity of the horizontal spread, but also, crucially, for its downward and lateral spread, which was so unusual by reason of the extensive pooling of the molten product at the top of the building in the architectural crown. Now, the London Fire Commission's position, as you know, and that of fire and rescue services nationally, as far as we're aware, is that historically a very high degree of reliance had been placed on the provisions of the building regulations as a bulwark against catastrophic, all-consuming fires in residential buildings of the kind which occurred at Grenfell Tower. And it was those regulations which existed to prohibit the use of dangerous materials, such as ACMPE, from being used. Now, in light of the evidence given in Module 6b, it is clear that in the years leading up to the Grenfell Tower fire, with actually very few exceptions, the limited extent of the Brigade's knowledge of the risks of ACMPE materials and its reliance on the effectiveness of the building regulations was, it would seem, broadly shared across the fire sector and by government itself. In our written submissions, we have set out some key evidence in Module 6b of witnesses from the responsible government department, DCLG at the time, and from the BRE, formerly the British Research Establishment, most of those witnesses were highly experienced technical advisors in relation to the built environment. Now, in setting out that evidence, though, we do not seek to criticise individuals or point the finger of blame. Those are obviously matters entirely for you, for the panel, when you consider the context in which they had to perform their functions in the at least perceived climate of deregulation at key moments. But for present purposes, we just want to highlight, if we may, two important points which emerge from that evidence in Module 6b. First, notwithstanding the failed test of an ACM panel by the BRE in 2001, which was reported to the Government Department in 2002, but not published until after the Grenfell Tower fire, none of those particular witnesses, those who gave evidence on behalf of the Government Department or the BRE, none of them was aware of the use of ACMPE panels on high-rise residential buildings in the UK, save for Dr. Colwell and Mr. Martin, from about 2014. And to the extent that there was a growing awareness of the risks, there was obviously a failure to appreciate the extent of the hazard and, again crucially, communicate it more widely to the industry and the fire sector. Secondly, although there was an awareness of international fires involving ACM, there was a firm belief that those fires would not occur in the United Kingdom, partly because ACM was not thought to be widely in use on tall buildings, but partly, and perhaps mainly, because the building regulations were said to prohibit such use. And indeed, the Government Department expressed views to that effect when asked by multiple parties, including fire and rescue services, in light of fires involving ACMPE materials abroad. David Crowder, Dr. Crowder, and it must be remembered, he is and has been for a number of years, a very highly respected expert in the field, in the fire sector, and someone with a great deal of experience and knowledge, was of the view, you'll recall when he gave evidence, that was an industry-wide belief. That is faith in the building regulations and an absence of knowledge of the use of ACM materials in high-rise buildings. To take one important example, this is how I'm now repeating things that have been said this morning, but it is worth it. Following the torch fire in Dubai in February 2015, the government's chief fire and rescue advisor was informed by the Government Department later that month that the dangers posed by ACM PE materials, cladding, should not be a problem in the UK because, quote, there are provisions in the building regulations to prevent this kind of problem. And the same broad view was expressed by the department, for example, in response to queries about the Address Hotel fire, also in Dubai, in late January 2016. And that may be one reason why there was no system in government by which requests for information from foreign governments about foreign fires were routinely made. No warnings by government were disseminated more widely of concerns expressed, for example, and this is where there was an acknowledgement of the use of ACM, but no warnings were given or information disseminated about concerns expressed, for example, at the CWTC meeting in July 2014, that ACM may be in common use, or the expressions of concerns from Nick Jenkins, if you remember, of Booth Murie in February 2016, that confusion over the interpretation of approved document B to the building regulations raised a risk of a fire in the UK like those in Dubai. It seems that those concerns were not escalated to senior officials in the department, again, failing to appreciate the extent of the hazard. Now, the London Fire Commissioner acknowledges, and has said, I mean, you know this from the evidence, that the Brigade wrote to central government and to housing providers on a number of occasions from at least 2009, raising general concerns about materials used in the construction and refurbishment of residential buildings and about levels of compliance with the building regulations. Now, while those concerns did not relate to ACM-PE materials, because they were not known to be widely used, the Commissioner accepts that more could, on reflection, that more could have been done to highlight with government a growing awareness of the possibility that the regulations were not always being adhered to or were being interpreted in a way which impacted on fire safety. It's in that context that part of the reason why the Brigade wrote to government seeking greater clarity in the terms of the building regulations, as did the Lackenall coroner in the Rule 43 recommendations, was that there was an important link to issues of enforcement of the regulatory reform fire safety order for which fire and rescue services are responsible. There's a direct link between the two. Now, that hasn't been the focus of a lot of attention during the course of the inquiry, but it is important that I make the point because in a great many cases, proof of a breach of one or more of the duties held by responsible persons under the fire safety order, or indeed where such persons want to argue that they did all that was reasonably practicable to meet the duty, defending their position. Where those arguments occur, they are dependent very often on an analysis of the requirements of the building regulations and British standards, and those two are really inextricably linked. The evidence in Module 6b, as we know, has highlighted a number of areas within the regulations where interpretations, especially in relation to ADB, vary to a significant extent. We also heard, I know it's Module 7, but it's relevant to this, that the combined effect, just for example, of Regulations 8 and 11 of the building regulations is that more or less a complete discretion is given to depart from the express requirements. This is for building control departments, so long as, quote, reasonable standards of health and safety for persons in and about buildings are demonstrated. Now, the point of our making that submission to you, it's not in our written submissions, is that as long as there is uncertainty of interpretation of the regulations and the statutory guidance, combined with the wide discretion which is vested in local authority building control departments to depart from those express requirements, there will continue to be real challenges in the enforcement of the fire safety order against building owners and responsible persons for fire and rescue services around the country. But what is and always has been certain, this is my final point, what is and always has been certain about the building regulations, as Mr. Martin accepted during his evidence, is that they do not allow for the contingency that stay put as a safety strategy might have to be revoked. They just don't provide for it at all. And that a full-scale emergency evacuation ensue. Such an eventuality is just not contemplated. And I've said it before, but it's particularly pertinent to 6B. And as a consequence, these kind of buildings were not designed to facilitate evacuation, as you know. Now, following the fire, the tragedy in June 2017, for buildings in London, they've been inspected by the LFB and others. Just over 1,000 out of a total actually of 29,000 odd, both high-rise and low-rise residential blocks. Just over 1,000 have been identified to have potentially dangerous cladding. And for those buildings, evacuation plans, temporary fire alarms and so on, waking watches, that sort of thing, have been put in place by building owners and responsible persons following the National Fire Chief Council's interim guidelines. That's the position in those buildings. And of course the Brigade has new processes to assist in effecting those strategies. But in general terms, if stay put as a principle of building design is to be abandoned, as Professor Torero suggests, as you know, it would obviously be necessary, as he says, to fundamentally change the regulatory approach. You can't just change it overnight, including ADB, and to establish multiple redundancies within the safety system to enable mandated phased evacuation, and that would include sprinklers, as we know, smart alarm systems, and many other fire suppression measures, levels of redundancy. Now, the LFB has campaigned for the provision of sprinklers for many years, and currently campaigns for additional protected escape stairways. So, if and when such changes are implemented by government, there needs to be political will, of course, as we know. The LFB will purposefully engage in making it work. All reasonable efforts, of course, need to be made to ensure that residents, including those with disabilities, have an opportunity to evacuate and ought to be supported in doing so in the event of fire. And that is about the way in which buildings are designed and refurbished and built. And that shouldn't be done by seeking convenient interpretations or loopholes in the statutory guidance about which we have heard so much. Or, to echo the words of Stephanie Barwise, Queen's Counsel this morning, deliberate manipulation and deliberate non-compliance. And that's all I have to say on behalf of the Commissioner.
Well, thank you very much indeed, Mr. Walsh.
Thank you.
Well, now the last statement due to be made today is going to be made by Mr. Glasson, Queen's Counsel, on behalf of UCAS. And Mr. Glasson is going to make his statement by Zoom, and we're rather earlier than we thought we'd be at this stage due to the expedition of other counsel. But Mr. Glasson, I can see you there waiting to speak to us. Is that right?
That's right, and I hope you can see me and hear me as well.
Thank you very much. And I take it you can see us, and you don't need to hear us particularly, but we certainly need to hear you. I'm sorry we've come to you rather earlier than you probably expected, but that might be a good thing in any event.
Absolutely. I'm sure on a day like this, everyone would like to be able to finish early.
Well, we are ready to hear you, so if you are ready to address us, please start whenever you're ready. Thank you.
Good afternoon, Chairman, Sir Esteban and Mr. Akbor. The United Kingdom Accreditation Service, UCAS, has, as you know, filed a written closing statement And in these oral submissions, I'm going to expand on some of the points that we've made in writing, picking up on occasion on some of the observations made in the written statements by the other core participants. At the outset, I would like to repeat UCAS's expression of sympathy to all the bereaved, survivors and residents of the Grenfell Tower fire. I also want to emphasise on behalf of UCAS 2 central points. First, UCAS recognises the strength of feeling expressed in the written statements from the bereaved, survivors and residents groups. UCAS recognises that the strength of feeling is justifiable, as UCAS acknowledges that some of the evidence relating to the BRE and to the BBA demonstrates that improvements are needed on the part of UCAS. Secondly, and relatedly, UCAS is committed to learning all that it can from the Grenfell Tower tragedy, and UCAS is acting now on those lessons. It's that second aspect that I would like to focus on this afternoon, particularly as it will serve to foreshadow the evidence that UCAS intends to serve in October in response to the inquiry's request for statements from core participants who have implemented or who are implementing relevant reforms since the fire. UCAS sought to respond to the fire swiftly. For example, UCAS conducted a number of additional visits to the conformity assessment bodies, CABs, in 2017. UCAS contributed to the independent review of building regulation and fire safety by Dame Judith Hackett that was published in May 2018, and has contributed to the ongoing independent review of the construction products testing regime conducted by Mr. Paul Morell and Ms. Annalisa Day, Queen's Counsel. Both reviews posed specific questions as part of the consultation, and UCAS has responded to those with detailed submissions providing information, identification of gaps and shortcomings of the existing regime, and suggesting recommendations. As we explain in the written statement, UCAS has identified a number of key areas to focus on in response to the tragedy. Those areas are in addition to the work that UCAS has undertaken specifically in relation to the BBA and the BRE that I will come to at the end. The first key area of work relates to product certification activities. All existing accredited product certification schemes are being reviewed to ensure that they remain fit for purpose, are meeting end user expectations, and are adequately described in the scopes of accreditation. There are literally hundreds of those schemes. But in the past 12 months, UCAS has commenced a programme to review construction product certification schemes. UCAS has identified over 70 schemes which are being reviewed. That is involving an in-depth evaluation of the scheme criteria against the requirement of accreditation standards. Generally, the reviews are taking place alongside annual assessments to CABs. But specific attention is being given to those schemes that do not utilise national or international standards or criteria set by regulations. For schemes that utilise criteria set by the CAB or by another scheme owner, this review is likely to be completed by the end of 2022. Further information on the review will be provided by UCAS in its statement of inquiry later this year. The second key area relates to UCAS's assessment processes. Aspects of the assessment practice are being reviewed to see whether there are sufficient checks that ensure that the scope of accreditation is adequately covered, having regard to the risks associated with that particular scheme over a 4-year assessment cycle. That has involved a number of different strands of work. Developing further processes to evaluate risk in the planning and conduct of assessments, To that end, UCAS established a project in 2020 aimed at developing an evaluation tool to be used for the assessment of each CAB. Criteria have been developed that take into account the scope and operating model of the CAB, as well as the sectors in which it operates. The tool has been piloted in 2 sectors, and plans are being established to fully embed the process within UCAS. UCAS is establishing a new assessment portal in its IT system. As part of that, a new reporting format has been piloted that will provide improved data to enable trends in CAB performance to be monitored and to ensure that a root cause analysis can be conducted. There's also increased monitoring of the effectiveness of corrective actions carried out by CABs, which is being established through additional training and ensuring that sufficient time is allocated to review corrective actions on assessments. UCAS is also developing further guidance on the appointment of assessors to ensure any threats to impartiality are mitigated. As part of that, UCAS intends to introduce additional monitoring and audits to review how those threats are being mitigated. The third area relates to technical expertise. A full review of the operation of technical advisory committees is underway. The committees will in future be managed by a central secretariat, which will enable harmonisation of best practice and increased oversight and enhanced management. There's ongoing work to ensure that there is a sufficient pool of technically competent resources and additional mentoring, which will be made available for new staff and for assessors. That additional mentoring will strengthen technical expertise available to UCAS. The fourth area relates to improving mechanisms for handling any significant non-conforming work that occurs in CABs, and that will include a more detailed and structured technical review. UCAS has emphasised to CABs and to UCAS's own staff that there is a duty of candour on the CABs to report concerns regarding performance of CABs that UCAS accredits. UCAS has long had a learning culture, and the importance of learning from adverse incidents will continue to be reiterated in training and all aspects of UCAS's operations. The final key area of work that I'd like to draw attention to is in relation to the proposed amendments to the customer agreement. In the course of Lorraine Turner's evidence, you pointed out, sir, that a number of the difficulties that have arisen in relation to UCAS's role could be addressed by amending the customer agreement. UCAS respectfully agrees. It's undertaken a review of the customer agreement with CABs, and it's instructed external lawyers to advise on revising the customer agreement. Many of the proposed amendments strengthen and, in some cases, clarify existing provisions and powers. Nonetheless, the amended customer agreement will enable UCAS to be confident that it will be able to adopt a more robust role with CABs, and that the agreement will address some of the issues that have been raised in this inquiry. The proposed amendments will go to a wide range of issues, and we've detailed those in section C of the written note. And just highlight a few points that are particular relevance. The first, sir, is in relation to the power to make unscheduled visits. Although this power was already implied in the existing customer agreement, the amended agreement makes that power explicit. The amended agreement specifies that UCAS may, at its sole discretion, carry out additional or unscheduled visits, in particular in order to verify that any notified changes to its requirement for accreditation have been implemented. The second is in strengthening the obligations owed by the customer, the CAB, to UCAS. The amended agreement will impose more onerous and exacting obligations on the customer. It will provide that the customer must ensure that any information it provides to UCAS, whether as part of an application for accreditation, an assessment or otherwise, is true and accurate in all respects. The customer must notify UCAS as soon as is practicable if the customer becomes aware that information provided to UCAS is false or inaccurate. The customer must take all appropriate steps to correct any statements used by itself, any of its officers, employees or representatives, any of its clients or any other person with which it is associated, which could bring accreditation into disrepute or could be misleading, regardless of whether it's been notified of the statement in question by UCAS or from any other source. And finally, the customer must action each mandatory improvement action raised in a UCAS assessment report within the period specified by UCAS. The third area is in relation to the definition of significant non-conformity, as well as the notification provisions. The draft amended customer agreement will set out an extensive definition of significant non-conformity and will impose an obligation on the customer to notify UCAS as soon as is practicable following identification of any such significant non-conformity. What the draft amended agreement will do is to reconcile the confidentiality obligations imposed on UCAS with UCAS's wish to ensure that a CAB cannot prevent disclosure of significant non-conformities to regulators or users or other interested parties. Just in terms of the confidentiality obligations imposed on UCAS itself, you may recall that in her second witness statement, Lorraine Turner explained that UCAS itself is held to ISO 17011, which imposes confidentiality obligations. Clause 8 of the 2017 version, which is currently applicable, is the confidentiality clause. It may be helpful just to see that on screen. It's provided at page 14 of UCAS 0011 44.7. See, at paragraph 44 of the written note, we set it out, and the relevant provision draw attention to is in 8.1.1. The accreditation body should inform the conformity assessment body in advance of the information it intends to place in the public domain. And then critically, except for information that the conformity assessment body makes publicly available, or when agreed between the accreditation body and the conformity assessment body, all other information obtained during the accreditation process is considered proprietary information and shall be regarded as confidential. I think we can move that from the screen.
Yeah, thank you.
The draft amended customer agreement will ensure that UCAS can comply with that confidentiality obligation, but at the same time ensure that it can alert stakeholders, end users and the public to any safety related information. To that end, the draft agreement will provide that the duty of confidentiality will not apply to, quote, any disclosure made by UCAS in circumstances following its apprehension or notification of any significant non-conformity or customer failure, close quote. And as I've said, there's an exhaustive definition of what significant non-conformity means. So the changes will make clear beyond doubt that any instance of fraud on the part of the CAB would allow UCAS to depart from its obligation of confidentiality, a point we know which was discussed in oral evidence and which has been commented upon by some of the core participants. The customer will be under an obligation to notify any significant non-conformity to all interested third parties, including its clients, product manufacturers, regulators, or impacted members of the general public. It will be for the CAB to identify any relevant impacted members of the public, and UCAS will ensure that sufficient action is taken. Who will fall within that definition will depend upon the nature of the accredited activity. And in the written note, we give the example of a failure by a hospital laboratory, which would mean patients of that laboratory. Compliance with this obligation will be through assessments of CABs and monitored by the UCAS Technical Quality and Risk Team. Then in relation to sanctions available to UCAS, again, you will recall perhaps from the written evidence that Lorraine Turner explained that a CAB's failure to report significant non-conforming work, or indeed non-conforming work to UCAS, would be sufficient to attract sanctions, although there would be consideration of the relevant circumstances such as, and I quote from her statement, the reasons why the CAB did not inform UCAS, the associated risk, and the actions taken by the CAB to correct the issue and address the root cause of the significant non-conforming work. There's a range of sanctions available that are detailed in the draft customer agreement, including terminating an application for accreditation or refusing an application, withdrawing, suspending, or partially suspending an accreditation, reducing the scope of an accreditation, requiring a further assessment of the customer, and publishing that fact and the suspension or withdrawal of the accreditation in any media it considers appropriate. Now, in terms of publication of sanctions, at the moment, UCAS website confirms which organisations are currently under suspension or have had their accreditation withdrawn. The information identifies where the suspension has been imposed as a sanction. This information is kept up to date to reflect the current status of the CAB. If a member of the public wishes to find out whether a body has been accredited or subject to a sanction in the past, they're able to request this information from UCAS directly. UCAS is currently reviewing whether the historical record of sanctions could be retained in the UCAS website and whether this information is of use, bearing in mind 2 points. First, that the current status of accreditation is always available via the website. And secondly, and critically, UCAS will not lift a sanction without confirmation that the issues that led to the sanction have been properly addressed. So as well as those major areas of work by UCAS in response to the fire, there's some specific areas of work that we mentioned in the written note that are worth drawing brief attention to, bearing in mind the closing statements that have been made by the other core participants. First, the Construction Industry Technical Advisory Committee. UCAS is reviewing whether to include fire performance testing of building products in that committee or whether to establish a standalone committee. That's ongoing work. Secondly, picking up on some of the observations made by the core participants in their written statements about UCAS's relationship with government, UCAS is working with BAYS to conduct a strategic review of accreditation and accredited conformity assessment. This work is expected to be completed over the summer and may result in changes to the BAYS UCAS Memorandum of Understanding. As I indicated at the outset, UCAS has also focused on the accreditation of the BBA and BRE. First, in relation to the BBA, in his statement for the inquiry, Mr. Randall from UCAS explained at paragraph 15.3 that, quote, following the annual surveillance visit to the BBA in January 2021, UCAS has undertaken a review of the BBA scheme, which has highlighted the need to update the references on the BBA schedule to reflect better the scope of the scheme, close quotes. Recently, UCAS has concluded the review of the BBA scheme and completed the annual surveillance assessment. That review indicated that a number of changes to the BBA scheme were required to enable UCAS to continue to include the BBA scheme within the scope of BBA's accreditation for product certification under ISO 17065. Alternatively, if the scheme is to continue in its current format, UCAS considers that it could be appropriate to transfer the accreditation to ISO 17020 as an inspection activity. UCAS is currently in discussion with DLUC and with the Office for Product Safety and Standards in its role as the new construction product regulator to work with BBA to determine next steps and the future direction of the scheme, taking into account that the scheme is used in industry to support evidence of compliance with the building regulations. We intend to provide further information on the scheme review in the October statement of inquiry. As to the BRE, in April 2022, UCAS staff met with BRE staff to discuss ongoing assessment to ensure that the requirements of ISO 17025 were met. UCAS emphasised the need for close monitoring of the effectiveness of corrective actions from previous assessments and the need for improved internal audits within the laboratory. The next assessment is taking place this month, where the issues highlighted in the evidence presented to the inquiry will be covered. A planning meeting has been held with BRE with respect to the coverage of the fire testing scope. It was noted at that meeting that the level and frequency of witnessing the fire testing activities has been increased. Additional monitoring and review of the assessment and post-assessment activities is being implemented. Drawing to an end, sir, I said at the outset that UCAS accepts that the evidence to the inquiry has heard in relation to the BBA and BRE assessments indicates that lessons need to be learned. Notwithstanding its acknowledgement that there are lessons to be learned, UCAS does not accept that it's fair to say that the evidence suggests that as an organisation it's not fit for purpose. Assessments are necessarily a sampling exercise, and they cannot guarantee to find all areas of non-conformity. As acknowledged by some of the core participants, sampling is a valid way of monitoring. The CAB's own system should require ongoing monitoring of compliance with the requirements. UCAS conducts a huge number of assessments each year. We calculate that over 30,000 assessment days per year are conducted using peer experts. What the inquiry has seen is, of course, a very limited snapshot of those. However, what the inquiry has seen is that UCAS has raised multiple non-conformities. It's not correct to say that UCAS does not wish to find problems. What the inquiry has also seen is that UCAS has witnessed tests. For example, in relation to BRE, during the period 2012 to 2016, UCAS took a fire testing expert each year, typically spending 4 to 6 days each year looking at the testing, including resistance to fire and witnessing a number of tests. It's recognised that the full BS 8414 test was witnessed only once in that period. However, the report submitted to the inquiry demonstrates that multiple fire testing records were examined and staff, equipment and facilities were assessed each year on site, in addition to a sample of other fire resistance tests. It is unfair to say that UCAS does not raise criticisms because it's funded by the CABs. UCAS has in place robust safeguards to ensure that it can retain its impartiality and perform its accreditation function effectively despite its funding model, which, as we say in our written note, is one shared with other accreditation bodies internationally. We've sought to explain those safeguards at paragraphs 17 to 21 of our written note. It's also important to bear in mind that UCAS itself is not a regulator. It has no legal or enforcement powers. UCAS itself is subject to a peer evaluation process, and like all recognised accreditation bodies, submits to a programme of peer evaluation to maintain its European and international mutual recognition agreement signatory status and its status as the UK's sole national accreditation body. The peer evaluation last took place in May 2021, where a team of 13 accreditation specialists from other European accreditation bodies spent a week with UCAS. This evaluation included observation of live assessments and detailed inspection of case records across all sections of the organisation to determine the effectiveness of the assessment process and compliance with the international standard. In addition, the peer evaluation team scrutinised UCAS's impartiality, as well as the effectiveness of the management system and overall technical competence. The review identified areas for further improvements, but concluded that UCAS has robust processes and systems in place that provide confidence in the reliability of the accreditation service that UCAS delivers. No systemic risks were identified with the UCAS system. All of those points, however, are not made in any way to detract from UCAS's acknowledgement that lessons need to be learned and are being learned. That fact, I hope, has been demonstrated by the detail that's set out in our written statement, and which, as I've said, will be developed in our October statement to the inquiry. So those are the submissions on behalf of UCAS.
Well, Mr. Glasson, thank you very much indeed. You managed to complete well within the time that we estimated for you, so thank you very much. And that brings us to an end of the proceedings for today, but tomorrow we shall have some further closing statements on behalf of other core participants. Not tomorrow, no, I'm reminded, not tomorrow is a terrible day for everyone trying to travel anywhere. No, we're going to sit on Wednesday. So we shall not sit tomorrow at all. We shall sit on Wednesday at 10 o'clock when we shall hear the further closing statements from other core participants. So thank you all very much. Wednesday at 10 o'clock, please. Thank you.